Great. Okay, good afternoon. I'm Richard Fulton. I am Senior Fellow for Religious Freedom at the Freedom Forum in Washington, D.C., and also co-chair of the Religious Freedom Committee of the ABA section of Civil Rights and Social Justice. And I'm thrilled to be with all of you here this afternoon and to have the opportunity to present and moderate a timely panel, perhaps even more timely than we expected when this was first scheduled, titled, For Heaven's Sake, the Intersection of Anti-Discrimination Legislation and Autonomy of Religious Institutions. Sponsored, as I already said, by the ABA section of Civil Rights and Social Justice, this panel is one of many in a series of timely webinars, both relating to COVID-19 and more generally, that the section has been actively planning, and we are actively planning additional programming on a variety of issues. So please visit americanbar.org//CRSJ for updates on these programs. During today's program, we encourage you to ask questions of our panelists through the Q&A, not the chat function. If you do not see the controls, please assure that your screen is not idle. I'm sorry, I'm just having a minor technical glitch here. If you do not see the controls, please ensure your screen is not idle. We will address your questions at the end of the panel. We will be sharing a recording of this program to everyone who has registered so that you can share it widely with your networks. We have a distinguished panel with us today. I'm going to introduce our speakers only very briefly. Their impressive credentials appear at greater length alongside this resource material that we are providing online. So I'm pleased to welcome to our discussion in the order in which I will initially turn to them. Jennifer Pizer, Law and Policy Director for Lambda Legal, who previously directed Lambda Legal's Marriage Project and more recently helped to draft the Equality Act and the Do No Harm Act, which we will be discussing this afternoon. We will then hear from Stanley Carlson-Thies, founder and senior director of the Institutional Religious Freedom Alliance, housed at the Center for Public Justice, who previously served at the White House Office of Faith-Based and Community Initiatives under President George W. Bush and helped to draft the Fairness for All Act, which we will also be discussing this afternoon. We will then hear from Jonathan Smith, Deputy Secretary for Civil Rights and Workforce in the office of New York Governor Andrew Cuomo. And Jonathan was formerly with Muslim Advocates, before that an attorney with the Civil Rights Division at the Justice Department. And finally, we will hear from Melissa Rogers, Senior Fellow in Governance Studies at Brookings Institution, formerly Director of the White House Office for Faith-Based and Neighborhood Partnerships under President Obama, and author of Faith in American Public Life, a book published in late 2019 and available on Amazon. Before I turn to our panelists, let me set the background. There's perhaps no more challenging an issue, and certainly few that give rise to higher passions, than the question of how to draw the balance between protecting the ability of faith-based institutions to operate in accordance with the tenets and safeguarding all Americans from invidious discrimination. That balance drawing goes back at least to 1964, when drafters of Title VII of the Civil Rights Act, which prohibits employment discrimination on the basis of race, national origin, sex, or religion, exempted religious institutions from complying with the prohibition on religious discrimination in employment decisions. Later, in 1993, in response to the famous, or perhaps depending on your point of view, infamous, Supreme Court decision in Employment Division versus Smith, Congress enacted the Religious Freedom Restoration Act, which provides for religious exemptions from federal laws unless those laws serve a compelling interest that cannot be met by more narrowly tailored means. Some states have their own RFRAs, others apply the RFRA standard as a matter of judicial interpretation, or apply the so-called Smith standard, which does not require a religious exemption from a generally applicable law unless it has been enacted for a discriminatory purpose. Finally, in 2012, the Supreme Court in Hosanna Tabor versus EEOC recognized the so-called ministerial exemption, which insulates religious institutions from discrimination claims generally, not just from claims of religious discrimination with respect to ministers, and ministers being a legal term of art that includes, but is not limited to, ordained clergy. There are several bills pending in Congress that in one way or another present varying approaches to the interaction of the fundamental societal interests of combating invidious discrimination and protecting religious freedom. The Equality Act, which would add sexual orientation and gender identity as protected categories to long-standing civil rights legislation, including the Civil Rights Act of 1964, and in doing so, would exclude the assertion of RFRA as a defense to those civil rights laws, as well as broaden the definition of public accommodations to which civil rights laws apply. The Do Not Harm Act, which would disallow assertion of RFRA as a defense not only to civil rights law, but also to laws regarding child labor and abuse, healthcare, federal contracts and grants, and government services. And finally, for purposes of our discussion today, the Fairness for All Act, which represents an effort both to expand federal protections against discrimination on the basis of sexual orientation and gender identity, and also builds into the law protection of the ability of religious institutions to operate in accordance with their religious tenets. Panelists will present views from diverse perspectives on the merits and demerits of these approaches and on the larger question of how best to draw the balance between protecting the ability of faith-based institutions to operate in accord with their tenets while safeguarding all Americans from invidious discrimination. Now, as we sit here this afternoon, and as we all know, this last Monday, the Supreme Court handed down a landmark decision in the case of Bostock v. Clayton County, holding that discrimination on the basis of sexual orientation and gender identity is encompassed by the provisions of Title VII of the Civil Rights Act, 1964, that prohibit employment discrimination, quote, because of sex, unquote. And thanks to this ruling, it is now the law of the land that American workers are afforded broad federal protections against being denied a job or promotion, or being fired or demoted, or being subjected to a hostile work environment because of who they love or because of their gender identity. The decision in Bostock is pertinent to today's discussion as much for what it leaves unaddressed as what it says. The opinion of the court explicitly notes, and the dissents likewise note, the array of questions still in play as to whether and how religious institutions, among other employers, may be able to claim religious exemptions from the protections afforded to LGBTQ people under Title VII. While I expect that our esteemed panel will have a word or two to say about Bostock, I expect that the consensus will be that the issues that were on the agenda for today remain very much as they were as of 9:59 a.m. on Monday, and that our conversation will focus on those issues as opposed to a parsing of the particulars of Bostock. Having said that, I want to note the ABA, being a full education provider, is co-sponsoring a webinar immediately following this webinar, co-sponsored by this section and the Social Justice and the Commission on Sexual Orientation and Gender Identity on the Bostock case. And I encourage you to stay to the last minute, hear every golden word that we're going to say, and then turn your attention to the other webinar. We're going to break at 4:55 p.m. so that you'll have plenty of time to make that transition. A sign-up link is being provided in the chat feature of the Zoom platform, and more on Zoom logistics in a moment, but if you look in the chat, you should find a way to transition over to that other webinar. Before the court recesses for the summer in less than 2 weeks, we're likely to see decisions in 2 other cases relevant to today's discussion. In the first, Our Lady of Guadalupe School versus Mauricio Beru, the court will be deciding whether and to what extent the ministerial exception to Title VII established in Hosanna Tabor extends to teachers at private religious schools. In the second case, Little Sisters of the Poor against Pennsylvania, the court is considering, among other things, whether the Trump administration has the authority under the Religious Freedom Restoration Act, which I will henceforth refer to as RFRA, and the Affordable Care Act, ACA, to expand the conscience exemption afforded to employers from the contraceptive coverage mandate, otherwise known to some as Hobby Lobby 2. So as we consider the intersection of anti-discrimination laws and the ability of religious institutions to operate in accordance with their religious tenets, it's important to recognize that in both cases, America's most fundamental values are at stake. In too many instances, advocates in this arena have minimized and dismissed the equities and concerns on the other side. We hope to bring some light as well as reasoned respectful discourse to the table today. Turning then to our panelists, well, let me first say a word about, I've already mentioned about the Zoom, that you're being asked to ask your questions on Q&A, not on chat. And you can talk amongst yourselves on chat if you like. So as we consider this, turning then to our panelists, I'm going to ask each of you to begin with a 5-minute introductory statement that provides a broad vision of how you see these issues. I will help these matters along, I hope, by asking each of you a question to frame that presentation. Also, I'm going to ask you about the implications of false starts separately. So please don't feel obligated to squeeze that into your brief remarks. Following that, I will have some follow-up questions, which I will ask you to respond to even more briefly, and then we will turn to the audience for any Q&A that they may have. So Jenny first. Please share with us a brief critique of the Equality Act and the Do No Harm Act, with both a broad vision for what these bills are about and a description of what they will do, and with particular focus on how they deal with religious freedom concerns, in particular with respect to religious institutions. Jenny, it's all yours.
Okay, well, thank you very much. Delighted to be here. And let me start by saying I have provided 3 different handouts that are available for all of you. So please do feel free to look at them as a refresher, and I can't possibly cover everything that these bills would do, but those are there for you, and in particular about the Equality Act. So I want to start by saying something that I hope would be obvious, but it isn't always. So I'm not anti-religion, and I'm not anti-religious institutions at all. When I was coming out as a lesbian, which was quite a few years ago, my beloved grandmother, who was a devout Catholic, was just wonderful. She was a little puzzled, but she was just wonderful to me. And at the same time, my other beloved grandmother, for whom her Jewish traditions provided immense meaning and support, also was wonderful. My mother was raised with Catholic traditions and disagreements with those traditions by her father, who was Protestant. And what I take as a core value in my life is that religion and religious disagreements should never be imposed on other people. They should never be a reason for discriminating against people in public life. That being able to live together with our differences, that is the core essential American value that we need to hold dear, that the conflict and discrimination for religious reasons is really harmful. So that's my initial framing. With respect to the Equality Act, which I'll address first, we approached drafting that piece of legislation for the members of Congress with 2 key principles guiding us. One is that we wanted to achieve equal treatment for LGBT people under federal law. And 2, we did not want to diminish anybody else's rights against discrimination in that process, by which I mean we didn't want to lessen the standards that apply with respect to race discrimination or national origin discrimination in the project of providing clear, explicit statutory protections for LGBT people. To the extent that achieving that equality means reducing some people's right to discriminate based on religion against us, okay, so that would be diminished. But that everybody would have the same equality rights was the key goal. A couple of other key principles, we wanted to use the same existing civil rights framework because it's been there for more than 50 years. It's well understood. There's an enormous body of case law helping people understand what the terms mean and how particular problems should be solved. We didn't want to be starting over with a separate law that would be interpreted by courts probably as requiring different answers to some of those problems, since it's a different statute. I live here on the West Coast in California, and we went through some of this project earlier than we're doing it at the federal level. And so we took some lessons from that, and in particular, that if you have a separate law, which we had in California first, courts tended to give an answer to all these questions that the answer should be different because the statute was different, and that was a real problem. Couple of other key principles. We wanted to update the Public Accommodations Protection to bring it in line with the Americans with Disabilities Act and what many states have done in the intervening 50 or 60 years, so that it would be a more modern public accommodations law for everyone, to protect everyone on all the different grounds of discrimination, to cover things, for example, like retail, which is a huge omission in the federal law now, but also things like internet sales and Uber and Lyft and things that, of course, didn't exist some decades ago. And the last and really critical point is federal funding. It's incredibly important that federal dollars that support programs and services for the general public not be in the hands of folks who discriminate. I mean, if it's the public's money to serve the public and meet the needs of the public, then the public needs to be able to be employed and all members of the public need to be served. So those were key principles. With respect to the Do No Harm Act, really quickly I'll say, the idea with the Do No Harm Act is to update or and provide some clarity for the Religious Freedom Restoration Act, RFRA, because many people who supported the law when it was passed back in 1993 understood it to be about protecting people of faith from discrimination with respect to things like holidays and the Sabbath and items of clothing and food, but not a freedom to discriminate against other people or to harm people in other sorts of ways. So it specifies that those religious rights do not apply as a defense in certain areas, such as to provide an exemption to child abuse and child labor laws, laws about healthcare, laws about civil rights, wages and benefits, and government contracts. It simply says, in effect, there's a compelling government interest in enforcing those laws. The only way to achieve that interest is to enforce those laws, so people shouldn't have to go to court and have a lawsuit every time. We know the answer. Let's just not go through that exercise. That's what the Do No Harm Act would do.
Thank you. Thanks for your comprehensive response and for your brevity. Stanley, the Fairness for All Act has been marketed as a grand compromise. What is the vision behind this bill? And what does it do specifically as an effort to reconcile anti-discrimination and religious freedom concerns? And what do you see as the problems with the Equality Act and the Do No Harm Act that you are trying to solve? You're on mute.
There we go. I'm honored to be part of this distinguished panel. I'm in the Washington, D.C. area, so I'll be like a politician and kind of use the opportunity to speak, you know, to what you said, but maybe a little bit around it. The Fairness for All Act, H.R. 5331, was introduced in the House last December by Utah Republican Congressman Chris Stewart. And there's no way to walk through all the details. You can look up the law. So I thought to kind of think about the vision and background of what it's trying to do, that I would stress that. It would protect, as Richard said, LGBTQ rights in federal law by adding SOGI as protected classes in the major civil rights titles. So housing, employment, public accommodation, federal funding, also consumer credit, jury service, also adding some speech and privacy protections that relate to these changes, enacting the Safe Schools Improvement Act to combat bullying in public schools, and then at the same time, adjust, clarify, strengthen corresponding religious freedom protections, particularly for faith-based organizations. So that's kind of the package. And the goal is to address the key needs and concerns of both LGBTQ persons and those persons and organizations that maintain conservative views on sexuality and marriage. So this came out of 4 years of discussion between conservative religious freedom advocates and gay rights advocates, catalyzed by what happened in Utah in 2015, new laws to protect against SOGI discrimination in employment and housing while strengthening protections for religion. So that all happened in Utah. Obviously, at a federal level, this is not Utah in thousands of ways, but we thought the principles and aspiration were worthy to do something constructive that might find broad support instead of each side continuing to batter the other side as if only all or nothing combat is the way to go about things. But the impulse to work on a both and proposal, I think, goes back earlier than Utah in 2015. For example, in 2013, some LGBTQ advocates and some religious freedom advocates, including me, came together to successfully persuade the Democratic majority in the Senate and 10 Republicans to pass an Employment Non-Discrimination Act. And ENDA in 2013 would have brought SOGI non-discrimination to Title VII 7 years before SCOTUS acted this week. And at the same time, I think resolved in a way I thought was satisfactory anyway, questions about the rights of religious employers that the court majority just points to without resolving. And for me, the impulse to find a both and path goes back even earlier to work that I did with others, including Melissa Rogers and Richard Fulton, who I will not blame for what I'm now doing, to develop a consensus on principles and legal rules in the complex area of government funding of religious institutions. So I think trying to find some way to work together is important if we can do that. So there's a long prehistory for Fairness for All. I think it's supported also by the reality that a significant number of conservative religious people and religious freedom advocates do want to secure protections against anti-LGBTQ discrimination, and a significant number of people and advocates on the left side of the spectrum and in the LGBT communities believe deeply in protecting religious exercise, and many are themselves religious. So the idea here was to deal with the fact that in our society, we have these different views, in some ways conflicting, about sexuality and marriage. We live in the same society. How do we reconcile that? So there are different approaches. Fairness for All is one of them. I take it that there's a strong analogy in what we've tried to do with Fairness for All with religion. We're a society of many religions and varied philosophical commitments, but we have devised ways for people and organizations that belong to different religions, different philosophies, to live consistently with those deep convictions to a great extent without abusing the rights and freedoms of others. So we've devised mutual accommodations because the Constitution requires it, court cases require it, but it's always taken legislation to create the actual patterns, right? Which freedom goes how far? When does some practice have to be limited for the sake of other freedoms, other rights? For example, but we have found some solutions. For example, federal funding for childcare is distributed in a way that enables parents with different convictions to find a daycare provider they can trust, religious or secular. Similarly, in higher education, rules allow for both religious and secular colleges and universities, and students can actually take their funds to whichever one they think is appropriate for them. So I take Fairness for All to be a similar kind of effort. Don't leave it to the courts. They're important principles. Instead, ask Congress to do the essential work of thinking through the different characteristics of the various protected classes, and then the many varied situations where different rights come together, whether it's public accommodation, employment, whether it's a secular employer, religious, and so on, and then discover or create mutually acceptable solutions. Mutually acceptable, of course, doesn't mean that one side or the other regards them as ideal. That's what you would get if you just could do it by yourself. But things that protect everybody broadly was our effort. So just 3 really brief examples. In Title VII, add SOGI non-discrimination, but then clarify that a religious employer that consistently and fairly has been making staffing decisions based on religious doctrine won't be second guessed if the issue is faithfulness to the religion's teaching about sexuality and marriage. In public accommodation, broaden far out, just as Jennifer said, the institutions that are covered under Title II, but then affirm that core religious organizations aren't public accommodation when they occasionally welcome the broader public onto their campus and so on. And third, Fairness for All actually preserves RFRA with the idea that legislation can't cover every issue that arises. So there has to be a balancing test when highly important rights come into confrontation. So then just a final comment. I don't believe myself as a general principle, it's best to consider these kinds of issues either under the concept of discrimination or the concept of church autonomy. Church autonomy is sometimes appropriate, I think, but usually the need is to find how religious exercise can be strongly protected when other rights are also involved. And I think an autonomy concept doesn't take you very far with that overlap. And while there is often, and troubling, of course, evil discrimination that needs to be stopped, many instances of different ways of doing things can be legitimate, at least when the decisions are made in our diverse civil society, and there are limits to what people can do. And that's what Fairness for All is designed to accomplish.
Thank you. Thank you. Jonathan, you're now a civil rights policy attorney for the state of New York. How has the conflict between anti-discrimination and the religious freedom concerns of religious institutions played out at the state level? What anti-discrimination laws does New York State have in place, particularly with respect to sexual orientation and gender identity? And is there any provision for religious exemptions in those laws? And in any event, have there been cases in which religious institutions have sought such exemptions in the state of New York, and how have those cases been resolved?
Well, first, Richard, thank you for having me. It's a pleasure to be here with you and with the other members of the panel and to talk about these really important topics. I think it's also really great to have the perspective, the state level perspective present. You know, Stanley talked about the example of Utah, and while obviously what happens on the federal level is tremendously important, as an alumni of the Obama administration, I respect the powers of the federal government. There's also the reality that most things that happen in our country happen on the state and local level. And I think that's true for the conversation we're having here as well. So I think it's really important to recognize what's happening in DC, in Congress, by the federal government, but to also recognize that states and localities have a really important role to play in this discussion as well. In New York, you know, a few things. First, you know, just for context, you know, we do, as you know, unexpectedly, I would hope, have a free exercise clause in our state constitution, but we don't have a state level RFRA, which I think is important for some of what I'm about to say next in terms of the application here in New York State and how some of these issues play out. But besides that, I mean, one thing just to say from the outset about New York, which hopefully, again, most people know, and one thing that I think is really great about our state is that we are tremendously diverse in literally every sense of the word. You know, the Governor Cuomo often says that diversity is our strength as a state, and you know, certainly it's not just New York City, but really every part of New York State is diverse in terms of religious practice, in terms of racial and ethnicity, in terms of language, in terms of sexual orientation and gender identity. And one thing that's incredibly important here in New York is to make sure that we are respecting and giving dignity to all New Yorkers, regardless of what they believe, who they are, who they love, or how they choose to live their lives. We have, you know, done that in the context of religious communities in a number of ways. You know, we do have tremendous diversity, religious diversity in our state, and we've seen in painful ways how that diversity has been attacked. You know, we are just coming pre-COVID off of a really horrifying series of anti-Semitic crimes and hate crimes in the state of New York. You know, we've been the subject of anti-Muslim bigotry. And so I think we recognize, and certainly this governor recognizes, the need to promote and to support the diversity of all religious practice and people who don't have religious practice here in the state of New York. At the same token, we also have taken a number of steps to protect members of the LGBTQ community. Yeah, I'm definitely proud to say that New York was one of the first states, well before Obergefell, and one of the first large state to take action to recognize same-sex marriages and the equality that is due to all people, regardless of their sexual orientation. We do in New York have the oldest state-level human rights law in the country. We actually celebrated the 75th anniversary of that law this year. I know Richard's dogs are really excited about that, as we are here too in New York, because, you know, we are proud that we really have been a leader in terms of making sure that we are, you know, recognizing and protecting and have strong and robust anti-discrimination protections. We have within our human rights law, we do have statutory protections both for sexual orientation and gender identity. And our human rights law doesn't just apply to employment, it extends to places of public accommodation, to housing, to schools, to credit. And so it's a very broad-based law where religious protections, both for SOGI categories, but also for religion, for race, national origin, are all protected in the law. In addition to that, a number of our state agencies have also enacted a number of other protections for LGBTQ communities through regulations and other rulemaking as well. And so we have a really broad based protection for LGBTQ communities in the state of New York. Our human rights law, as I mentioned, which is celebrating its 75th anniversary, does include a carve out for religious organizations and entities that applies to all bases of which the law applies, so employment, housing, places of public accommodation that do provide those entities to seek relief under the provisions of that law for free exercise reasons. And so we, even in our human rights law, have found a way to balance that. We have also, have seen places where our human rights law, our anti-discrimination mandate has been viewed as coming into contact with free exercise rights. As mentioned, we don't have a RFRA in New York State. And so our approach to those disputes, have largely been based on looking at both federal and state constitutional provisions. Our state courts do look to the Smith decision, but beyond that, more recent post-Smith, our highest court, our Court of Appeals, issued an opinion in the early 2000s where they adopted a standard that's similar to Smith, but somewhat different for how free exercise claims would be evaluated, where there are quote incidental burdens on that exercise being alleged by entities or by parties. And what our court said in that context is that, similar to the general framework of Smith, that there needs to be a balancing act that happens after that. And on the one hand, the courts are directed to look to the actions of the legislature, recognizing that they should be given substantial deference. And then the burden shifts to the entity seeking relief for the, under the law to have them justify why they believe the legislation is in fact imposing what the court said, quote, unreasonable interference with their religious exercise. And the New York State Court of Appeals believes that this standard is in fact more protective of religious freedom than the Smith standard, and has interpreted that in that way. There's two quick examples I'll give for how that standard has been applied in recent years. One case from 2016 is very similar to Masterpiece Cake Shop fact pattern involving a place of public accommodation in New York State that rents out its facilities for weddings, and there was a same-sex couple that sought to get married there and was denied by the owners of that property. When our appellate court was looking at that decision, they ruled in favor of the couple on the basis that, while of course they didn't question the sincerity of the belief of the owners of the property, they recognized that there's the highest interest in the state in terms of ensuring robust protections of anti-discrimination law. And when comparing that substantial interest of the state, the kind of incidental interference on the owners was not sufficiently unreasonable to suffice as an exception. The second example, I'll say very quickly, is more recent, happened last year where, as some of you may know, we had a pretty severe measles outbreak in the state of New York, and there was questions about the religious exemptions under that statute, and the legislature passed a law that removed the religious exemption. And in the legal challenges that followed from that, the courts applied that same standard of balancing kind of the interest of the legislature with the kind of the burden placed on religious exercise. And in that case as well, the court found that the interest in preventing disease and outbreak and ensuring public health was paramount and was being done in a way that did not sufficiently infringe on religious exercise. And so, I would say that we have, I believe in New York State, have found a way to both recognize and respect the diversity of all of our residents. And I think that involves recognizing that we have to respect and value religious exercise, but we also can do that in a way that also allows for robust protection, anti-discrimination protections, including for LGBTQ communities.
Richard, you're on mute.
You're right. Yeah, yes. Thank you, Jonathan. And I think you're absolutely correct that we have to keep our eye on the states in terms of how to think about these issues. It's not just a federal issue. Melissa, could you talk to us about the pitfalls and concerns that we should be aware of as Congress legislates in this area? What are the threats to anti-discrimination or religious freedom, respectively, that come along with these various approaches? And what's your view on the relative, bear with me while I ask this questions. What is your view on the relative merits of RFRA's balancing test as opposed to the categorical exemption of certain classes of claims from its reach? And could you also address the expanded definition of public accommodation in the Equality Act, which has raised concerns among many religious institutions?
Yeah, so thanks, Richard, and thanks everybody for joining this webinar today. I'd also like to thank my co-panelists. I really appreciate all their work and have had the opportunity to work with most of them closely in various circumstances. So it's a great pleasure to be with you today. So Richard, I'll try to very briefly discuss some of the questions that you raised. First, I think that we ought to feel very encouraged and hopeful that the court came to the decision that it did this week. As you know, we're always looking for common ground in this area. And I think the court, by coming together in a 6-3 decision, indicated that there is some common ground here, and hopefully we can find more as we move forward. I've also found it encouraging that the decision has been greeted favorably, or at least not unfavorably, by many people. And so that's a step forward as well. You know, I want to applaud both the people who have worked on the Equality Act and the Fairness for All Act for trying to provide these much needed protections for LGBTQ people, while also grappling with the religious liberty issues that enter into these matters. And I think the decision gives us an opportunity to have new conversations, to have a fresh start to some of the conversations that may have stalled out. And again, as I said earlier, perhaps find some common ground. I think some of those discussions, we need to bear in mind that there's some difficult and challenging issues that are going to come up, and they've already been hit on by some of our panelists. I'll just mention 3 of them. One of them is the Religious Freedom Restoration Act. Richard, you mentioned that, and some have talked about that act, and there's a federal Religious Freedom Act and some state Religious Freedom Restoration Acts, and some state constitutions are read to provide this high level of protection for free exercise. Any substantial burden on religious practice has to be justified by a narrowly tailored, compelling state interest. And I think where people tend to divide is that there's traditionally been a high interest in not saying that RFRA does not apply to certain laws, so that we don't pick and choose in the free exercise area, subjecting some to higher or providing higher protection for some religious practices that we might like better than others. At the same time, I think many are concerned, especially at the federal level, about how the Religious Freedom Restoration Act has been interpreted by some on the court and by some in the Trump administration. And there's a concern by many who were involved in shaping the Religious Freedom Restoration Act that the court and the Trump administration have read that act too broadly in a way that gets the balance out of whack. So that is one set of issues and challenges to watch as we come back to the table legislatively. Another issue is also been mentioned by some of the panelists, the idea of treating LGBT as a protected personal characteristic the same as other personal protected characteristics, meaning like religion or ethnicity, or whether LGBT protections are treated differently and given less protection than other personal protected characteristics. And that is a huge flashpoint, and something that the court did not speak to or resolve. There weren't religious liberty claims in this particular set of consolidated cases that the court heard. So we're going to have to really continue to grapple with that. And the Equality Act and the Fairness for All Act deal with that issue in somewhat different ways. So maybe we can unpack that a little bit more. And then the third sort of issue that we have to grapple with is the question of whether, when government funding is present in a situation, or whether something is happening in the commercial sector as opposed to the nonprofit sector, whether that makes a difference. So I think those are just three very important issues that we're going to need to continue to grapple with. But as I said, I feel hopeful about the moment. I feel encouraged that we're having conversations like this one. I hope more conversations will ensue, both at the federal and at the state level. I also should say, however, that I think that we probably, even if we get legislation, we're probably going to end up back in the courts on some questions. And so that's just something that I think we can't dismiss, and we can begin to think about what that would look like if folks are interested in talking about it. So just a quick pass through some of your questions. Look forward to further discussion.
Great, thanks so much. So we've been talking about Bostock quite a bit already. What are the implications of that case for? And I put this question to all of you, anyone who wants to respond to it. If you feel you've responded to it already, don't feel obligated to say the same thing again. What are the implications for religious institutions for legislation in this area? Are the bills pending still necessary? Do they have to be modified in some fashion because of what the court ruled on Monday? Just your thoughts about how this topic relates to the court's decision on Monday would be appreciated.
Well, Richard, I'm not sure if you had intended me to plunge into that question, and I know we also can do some back and forth about the details or the comparison between the Equality Act and the Fairness for All Act. So maybe I'll tee it up with a couple of thoughts.
We'll get to that.
Okay. Well, in terms of the Bostock decision and are these the bills that I've worked on, are they still necessary? I'll take your breath away, I'm sure, by saying yes, they are still necessary. And do they need to be changed in various ways? No, they don't. I mean, and there's a couple of reasons for that. I mean, the most obvious one, and I think Melissa sort of spotlighted this, the majority decision is quite clear, and at the end of the decision, that it's not deciding issues of how religious liberty relates to the equality rights protected by Title VII, and likely by other federal civil rights laws that also forbid discrimination because of sex. And the majority opinion identifies a number of sources of religious rights that may be relevant in different circumstances, and is quite explicit, and it's obviously true, is not deciding those questions. From our perspective, there is an important, at least reference point that informs the way we think about the Equality Act, and the fact that the Equality Act does specifically say that the rights provided under RFRA do not provide a defense to claims under the Equality Act. And in a related way, the Do No Harm Act says that the rights provided under RFRA do not provide a defense against civil rights claims brought under federal law. And the reason for that, it is found in a rather neat package in the decision issued by the Sixth Circuit in Amy Stevens' case, the Harris Funeral Home case, which was one of the three that was decided on Monday. That's the case of a transgender worker who was fired when she came out as transgender. And the employer did in that case assert a RFRA defense that was looked upon favorably by the trial court, the district court. And at the Sixth Circuit, the analysis was done in a way that I think was correct, concluding that it's been well recognized that the government has a compelling interest in enforcing non-discrimination laws. And the only way, the least restrictive way of pursuing that goal, the goal of ending discrimination, is to end discrimination, to forbid discrimination. It's not overbroad. So it satisfies RFRA's test. So in our view, that's the appropriate way to look at it. The fact that that issue was not offered in the cert petition and the Supreme Court did not take it up means it is yet ahead of us for another day. And I think one thing we would all agree on is that there will be more litigation in this area, both under the Constitution, of course, but in construing RFRA, and if Congress does update it and amend it and clarify it as we think should be done for exactly the reasons that Melissa said. I mean, we could propose a bill that actually would peel the standard back to what lots of people understood it meant back in the 90s. That is, it was to be a codification of the case law that went before, that had included the idea that religious rights are not to be asserted at other people's expense. The sort of the impact on third parties was part of the case law, seems to have not been adequately captured in the drafting of the statute, and doesn't seem to be as robustly embraced by how we understand the RFRA statute after Hobby Lobby. So that would have been another way to go, but it seemed sort of really simpler for everybody to identify areas where it seems clear that there's a compelling interest and just say, we don't need to keep litigating in those areas. There's other areas that's open for everybody to figure out, but those areas we think we already have the answer to.
Stanley, I suspect you're going to have a similar response as to the need for legislation still even after Boston.
Yeah, for sure. I mean, Jennifer's right. The court just said we're not dealing with the religious employers, but here are a series of things that relate, but they didn't say how it relates, and so there you have the problem. I don't think it's a good idea to try to figure these out all in court cases. That's terrible for everybody, including all the other onlookers who may have a similar case, but that's not their particular one, and they're wondering what they have to do or ought to do. And it could well be that courts can't create in all of these cases, a solution that would be available if a legislature could step in and say there's a broader way to look at this, or we can arrange things in different kinds of ways. So I think there's still a reason for legislation, and I am worried about opening up RFRA. You can see why. I mean, at various times, Congress has talked about it. Sometimes Republican administrations have talked about it. Let's say that certain things like domestic security aren't subject to RFRA and so on. And it's fraught. I think I would look at the way discrimination ought to be dealt with just a little bit differently than Jennifer, but it is very complex if it gets opened up, that's for sure. And I think the court just said it doesn't really matter what the original intent was of anybody. There are the words on the paper. I actually don't endorse that, but I just wanted to throw that in since the court just said that this Monday.
So let me ask, before we move on to it, I actually have a question for Jonathan and anyone else who wants to respond to it. You spoke about the New York State case involving the hall that didn't want to provide services for a same-sex marriage, which I take it as a private, non-religious entity. So the question I have is, does it make a difference if the entity we're talking about is a religious institution? For instance, synagogues oftentimes have halls that they rent out for weddings. And so you could have a Catholic or an Orthodox Jewish or other religious denomination that makes their facility available for these purposes, generally to people of the same faith, not necessarily members of the congregation, that as a matter of their religious tenets, don't want to host a same-sex wedding. Does that make any difference that we're dealing now with a religious institution, or are they going to be obligated, should they be obligated to make their premises available for that wedding nevertheless?
Yeah, so as I mentioned, under our New York State human rights law, there is, explicit carve out for religious organizations and entities, and that does apply to the breadth of the human rights law. And I think that exception, which is similar to like the ministerial exemption under Title VII, is really designed to recognize that there are obviously an array of places where religious entities should have the right to make decisions based on their religious precepts and beliefs. And so I think we recognize that under New York State law as well. I mean, I think certainly the challenge is going to be that both under I think this is similar to what Jenny and Stanley were talking about, that obviously even when you have things in statute, that doesn't always resolve every fact pattern or every situation. There will be situations, I'm sure, under New York State law and situations, more broadly speaking, where those principles, come into or perceived to come into conflict. But again, I do think, going back to the way that New York State courts have approached this issue, I think there's a broader recognition that, there are going to be infringement on religious exercise and practice. And I think that, legitimately so, those that may look different in the context of a religious organization entity, alleging those rights. But, I think that the idea still goes back to that idea of balancing, right? That we have to really look at what the nature of that infringement is, how reasonable or not, or unreasonable is it, and whether or not the interest being asserted by the state, is substantial. And I think here, I mean, one thing that we've been really clear about, both from the courts, but also as a matter of public policy, and to echo like Jenny's point, is that, it's hard to really counter that the principle of robust anti-discrimination for all residents is not really compelling and really important, and that states particularly don't have a clear interest in making sure that those principles are being applied broadly. And so, I think that there are ways to strike that balance, but there is a fundamental recognition of the importance of of anti-discrimination. And the one other thing I would say, just in response to your prior question, which may be a somewhat non-response, one thing that we have found to be really important in New York State, and this is something that we just last year passed a law that have clearly enshrined protections for gender identity and expression into our New York State human rights law. It had been recognized, by regulation and interpretation before that, but it's really important for a whole array of stakeholders to not just rely on interpretation, but to have that clear recognition of right in law. And so I do think Boston is obviously an important decision for LGBTQ rights, but what's missing is that recognition of those rights in statute, and that's something that matters at the state level, and certainly matters arguably even more so on the federal level.
Hey, Richard.
Thank you.
Richard.
Yes, Rose.
So we're all in agreement that it'd be far preferable to have legislation, so that's a good thing. I just wanted to respond to a few things that have already been said. Stanley, you made the remark a moment ago, I think, that and I'm sure you're referring to the Bostock decision, that doesn't matter what people intended when they passed this statute, just what's on the paper. And I think the concern of those who feel that RFRA has been too broadly interpreted is not that, but rather that when the Religious Freedom Restoration Act, the restoration in that act's name referred to the pre-employment division versus Smith case law that employed the compelling interest test. And in the Hobby Lobby decision, Justice Alito said that that RFRA was independent from that case law, that it wasn't to restore that case law, but rather to remake it almost. So I think that's some of the concern that's coming from one camp about the Religious Freedom Restoration Act now, whether it actually is restoring the pre-Smith case law or remaking that case law. And then also I had a question for Stanley about the Freedom from Religion, the Fairness for All Act, about whether there are a bunch of balances struck throughout that legislation, and whether the framers of that legislation might be open to saying that the balances struck in that legislation represent RFRA's application to these matters in the judgment of Congress. Because if that's not the case, then I think you have a bunch of balances struck in Fairness for All. And if it were to pass, then you could still have RFRA challenges to those balances that would then upset those balances. So I just throw that out there for consideration. And then Jenny was talking about the do no harm principle, and I do agree that that's an important factor. My own view is that the court has spotlighted that as an important factor, although it hasn't come to a black and white decision about exactly how it works in particular free exercise cases. So I don't think it's a clear black and white thing, but rather it's a factor, and it's a factor that may differ depending on the context. It may differ depending on whether you're dealing with a commercial or a nonprofit, whether you're dealing with something that would be government funded or not government funded.
So, important points. We have a lot more ground to cover, but not enough time to cover it all, so I've got to pick and choose to some extent. Stanley, I want to ask you, while you have the endorsement for the Fairness for All Act from a number of right of center groups, it's opposed not only by progressives, as we have seen, by some of them, but also from the right. For instance, the Ethics and Religious Liberty Commission of the Southern Baptist Commission has said that the protection of people of faith are insufficient, and the legislation will use the federal government to impose a new orthodoxy on matters of sexuality and gender on the entire country through the Civil Rights Act. So, you know, this could be a much longer question, but really the question is, what's your response to this critique? Do you agree that you have bought into a radical new orthodoxy?
Hey, I'm guilty of many things. So just kind of briefly. So of course there are a lot of conversations that have been going on throughout the whole process, and as the language was being developed, actually it was shared with many groups on both sides, if we want to call them sides, that would never agree with the final deal. But we wanted to make sure that what we did wouldn't really be harmful to people. So, but you know, you can imagine that organizations part of whose job is to guard theological doctrine aren't too happy getting into the details of legislative compromises. And so I think that's one thing that's at stake here. I think one response I've had back to my friends at ERLC and U.S. Conference of Catholic Bishops and so on, is to say that, you know, what I think what we really need here is not just kind of a continual clash of big principles and throw it into the courts and let them decide, but you actually have to think about, you know, what does it mean for these different protected classes and rights to come together in specific kinds of areas, whether it's employment, public accommodation, whether it's a for-profit or not for profit. And to do that, you actually have to think about something like sexual orientation and gender identity, and what does that mean for religious exercise, and what does religious exercise mean here? You can't just leave these as general things and say, I don't like to put them in the law because there's some imprecision there, or maybe it'll endorse a view of humanity that I don't believe in. I think you just actually have to deal with the concepts. And so that's what we tried to do. And I know it doesn't satisfy many people on all sides. But we hope we made some progress down, you know, down the pathway.
Okay, great. I'd like to turn to you, Jenny, to ask a question, which, picking up on the question, first of all, how one responds to this idea that what's happening now is we're seeing the enactment of a particular theological perspective as opposed to protect and not giving due regard to religious faith interests. But I also want to invoke Justice Kennedy, who in Masterpiece Cake Shop talked about the concern that, you know, first of all, we need to protect against invidious discrimination against people on the basis of sexual orientation and everyone, and at the same time expressed his concern that we not make pariahs, just as it was shamefully wrong that gay people were made into pariahs in the society for far too long, that we not make pariahs out of people on the basis of their faith and make them unable to participate in the larger society because their faith puts them at odds with, more newer perspectives. How do you respond to that? What do we do about, should we avoid making pariahs out of people, and how do we go about doing it?
Yeah, well, let me start by saying that I very much appreciate the work that Stanley and some of his colleagues and quite a few people have been doing in having these conversations and trying to sort things through. And I don't find it surprising at all that a lot of time has gone into it and it's not all solved yet. And that's okay. I mean, some of us have been at it for a really long time. I mean, people keep talking about this overnight success of the marriage equality movement. And I'm like, yeah, overnight success. If you consider 40 years overnight, that's a long night. So it's, the conversation is very welcome, is the first answer. And the coming closer together and the finding some areas of common ground is very welcome. And so there's an offer, and some of us aren't ready to take the first offer, or maybe it's the 17th offer, but I mean, it's a process, right? And I would say also that there are aspects of this that are very familiar, at least to me personally, having spent a lot of years working on marriage equality and protecting family relationships for LGBT people, and the offer of domestic partnership, of like, why do you need marriage? Domestic partnership, isn't that nice? I mean, some people said that after, having said there should be sodomy laws. Okay, well, maybe, okay, how about this nice domestic partnership? And well, we could make the domestic partnership somewhat nicer. I mean, I had these conversations with my mother. And so I don't take them at all as having been in bad faith or coming from an unkind heart. I think that as we look, for example, at Justice Alito's dissent in Bostock, we see him invoking some tropes that are kind of familiar and pretty painful. And it reminded me of some of what we dealt with in the marriage work, of the concern that if same-sex couples could be fully within the family code and could marry like anybody else under civil law, that it would cause the sky to fall and it would be terrible for children and so forth. And, the reality is, like, we are who we are. If you believe in nature, it's how nature made us. If you believe in divinity, it's how God made us, but we are who we are. And so we need to have good, solid protections that cover the range of areas of life where it's appropriate for the government to regulate. This is not an argument for greater government regulation in places that we've recognized as being appropriate to keep separate. That's why the mantra that I keep coming back to is we have a set of rules. Lots of people will quibble with them, but they've worked more or less okay for a good while. And we should keep using them. And that's in our view, pretty much what the Equality Act is designed to do. I want to flag a couple of areas about the Fairness for All Act that illustrate why I think Stanley's work is not done, and I encourage him to continue coming in our direction. That one of the key principles that I started off with is that the rules should be the same for everyone, and in a number of important respects, and I understand why, but the Fairness for All Act sets up a two-tier standard where existing protections against discrimination based on race, color, or national origin are not the same for sexual orientation and gender identity. And those cover things like, for example, creating a new, essentially a small business exemption for public accommodations that we've not had before. So smaller business just wouldn't be covered for SOGI, but would be for race, color, and national origin. And there's a similar sort of loophole for online businesses. And there's some similar different standards with respect to federal funds going to schools and childcare entities, where the standards that exist for race, color, and national origin, which are incredibly important and have been transformative for our society, don't apply the same way for SOGI. And there's a number of others. Also, the definition of religious organization is broadened in ways that are, to our view, problematic. And there are issues about preempting explicitly or effectively state and local non-discrimination protections, and issues about blocking the ability of accreditation agencies to use professional standards when licensing, say, social workers and healthcare workers. And there are other things too. The point being that it's a lot of movement in a good direction, but in our view, it's not fairness for all. It's not equality in these public spaces for LGBT people. And the place I come back to for those who would really fiercely disagree but are still listening would be so many of our essential services in society these days that are funded by state and local money, and many of which are regulated by professional standards. So medical care and mental health care and social services of various kinds. Faith-based organizations have come into that space, especially more and more in recent years. And of course, Melissa is an expert in this field. And that was initially done with rules about non-discrimination, in particular about beneficiaries, but also rules about employment. I mean, the federal purse to reduce employment discrimination has been one of the hallmarks of why our society looks the way it does today. And so that's just incredibly important. If organizations want to be funded by public money to do work for the public, especially for people at their most vulnerable, people who are homeless, people who need nutrition support, people who need mental health care, it should not be done pursuant to religious standards. It should be done according to professional standards and the needs of the person. First, do no harm to the person who's in need. And I'll end this particular sort of explanation referring to in Masterpiece that Justice Kennedy talked about religion by citing the Piggie Park decision. The Piggie Park decision, the barbecue restaurant where the owners sincerely believed for religious reasons that the races should be segregated and therefore would not serve Black customers the same as white customers. And the Supreme Court said that the religious defense was essentially patently absurd. I mean, that if religion could work that way to create an exemption for the civil rights laws, they would have very little work left to do. He talked later in the opinion about free speech rights, but with respect to religion, it seems to me that cite was really important and should be guiding the way we think about how we regulate public spaces and public life.
If I might, before I turn to the last couple of questions, and then we want to get in a little bit of Q&A as well from the audience. That the key issue with, I mean, the headline at least, is dealing with religious institutions, and of course that may or may not be a different case, but that's not what that case was about. And that's what we need to wrestle with. And I just want to come back to the question about what's a public accommodation. If for instance, I don't know what your opinion of this, but if the catering hall of a synagogue becomes a public accommodation, then we're deputizing religious organizations as public accommodations, which itself opens up a can of worms completely aside from the implications for anti-discrimination law. And so that's, I don't know what Stanley's bill does with respect to those kinds of institutions, but I know there have been concerns among religious institutions that the Equality Act just opens up the door too broadly in terms of what can be considered public accommodation.
Just to clarify, I cite Piggie Park because of the small business exception that is in the Fairness for All Act. That's my reference.
Right. Okay. So I've got two what I hope are brief questions for Jonathan and Melissa, and then we'll turn to at least a couple of questions from our listeners. Jonathan, you previously, before coming to New York State, you were with the Muslim Advocates Organization. And as is evident from this conversation, if we don't know it already, there's no one voice for any religious community. I mean, there are Jewish and Christian groups on both sides, on all sides of the discussion we're having as to Equality Act versus Fairness for All Act versus don't do either of them. Do you have a perspective you could share with us on how folks within the Muslim communities have been thinking about these issues? Are those communities similarly divided as to what the best way is to go forward in dealing with these issues?
Yeah, first, I'm personally not Muslim, and so I'm definitely not going to pretend to represent the American Muslim community. But when I was at Muslim Advocates, certainly I was there when Masterpiece Cake Shop was decided, and I remember hearing from many members of the community who had concerns about what that decision could or would mean for them, in terms of their own concerns about many, I remember specifically a number of communities saying, we don't serve alcohol to people. Is this going to mean that we have to do that? Or is this going to be another way in which government is kind of legislating how we run our businesses? And so certainly there's a diversity of viewpoints in the American Muslim community, like in any community. But one thing that I would say, and actually, going back to Jenny's point about kind of the broader issue of discrimination and how it manifests, when we did at Muslim Advocates submit an amicus brief to the Supreme Court in Masterpiece Cake Shop, and the argument that we made there was that many times it's presented as a choice between anti-discrimination or religious freedom, and for many members in minority faith communities, that's not actually a real distinction, that those communities are both dealing with both of those challenges at the same time. And for many minority faith communities, there's a real question about their ability to even enjoy the anti-discrimination protections that we may take for granted in other contexts here. And so, I think, the point we made in our brief there, which I think has implications to this conversation, is that, it's not an either or, and really that if done properly, these principles should reinforce each other and reinvigorate each other, and really speak to the same goal of allowing full and meaningful participation in society. And I know one concern that is true for American Muslim communities, but I suspect is true for other faith communities as well, is that so often their daily life is defined by people using the pretext of discrimination or even religion to exclude them from service or from participation. And so the need to make sure that we are not somehow rolling back anti-discrimination protections in the name of religious freedom, when we may be harming, religious freedom by doing so, is, I think, something that's particularly acute for the Muslim community, but for other religious minority communities, and sometimes is, I think, lost in the discussion, where sometimes we do take maybe a majority or a kind of a Christian viewpoint for what discrimination looks like and why that's really necessary today going forward in our country.
Thanks, Jonathan. I have to confess, I lost my phone audio, so I didn't hear almost anything you said. I'm sure it was all very wise, and I look forward to the replay. But anyway, it's 21st century problem, I guess. Melissa, and this will be the last question to this group before we turn to a couple of questions from listeners. Just looking forward, are we facing an era of irreconcilable conflict, with each side demonizing the other, yet another example of how polarized we have become as a society, where any legislation that's enacted will only come as a result of the application of brute political power? Or is there a more hopeful scenario? So give us some hope, if you can, as to how we proceed from here.
Yeah, I'll just say that I think it's very encouraging that the court decided as it did on a 6-3 basis. That's progress, incredible progress, and I think we all can feel good about that. I also think it's very encouraging the work that Stanley and Jenny and all of their colleagues have done. That is real progress. We are much closer. I know it's taking too long than any of us would like, but there's real progress. So I'm always hopeful, and I'm hopeful now. At the same time, I would not at all underestimate the level of difficulty of the remaining tasks. These are just issues where people feel incredibly strongly. You can hear it in the conversation today, and it's very hard to find a way to resolve those issues. So that's why I think we need to keep the conversations going and hopefully find more common ground in the wake of this decision, while also knowing that some of these issues are going to ultimately be decided by the Supreme Court. And, that's likely going to be the case. I just wanted to close with saying, I love Jenny's phrase, for those who fiercely disagree, but are still listening. And I think that's a great phrase for this work, because that is definitely true. We've got some fierce disagreement, but also many of us are still listening to one another. And as long as we're still listening, there's still hope.
So good, you've given us hope. That's thank you. So I've got a couple of questions to throw out at you. Please be very brief in any responses you might have, because we then have to wrap it up in time for everybody to go and hear about BOSA webinar. So recently there have been several petitions asking the court to revisit the Hardison standard, which is the standard for applying for understanding Title VII's requirement of religious accommodation in the workplace, encouraged by several of the justices. What are your views as to whether or not an expansion of religious accommodation could potentially harm third parties in the pursuit of accommodation? And does that implicate concerns that religion is being established that way? So this is sort of a tangential but important issue. We know about RFRA and the constitutional interpretation of exercise. Here's the interpretation of Title VII's requirement of religious accommodation and what expanding that obligation might mean in terms of impact on third parties.
I wonder if I could take the panelists' prerogative to turn the question back to our esteemed moderator, who spent incredible amounts of time working on just these issues.
Yeah.
As you know, Melissa, and thank you for the plug. I did spend a lot of years promoting the Workplace Religious Freedom Act, which would have strengthened those standards. I long felt that the idea that this could be used as a basis for discrimination against other people, for instance, against LGBTQ people, because people would invoke a religious right, religious interest in, in pursuing their view of theology. The case law just didn't stand for that proposition, that religious accommodation, even with a strengthened standard, could lead to that result, that courts were not likely to allow the workplace to be disrupted in that way. And just as with civil rights laws generally, the compelling interest in prohibiting discrimination and preventing harassment would have mitigated against any such interpretation of an expanded law. So I continue to think that would be the case, but I didn't get many buyers on the side of those concerned about, specifically concerned about the LGBTQ community. And so I think that we'll have to wait and see what the court does and how they frame it. But I would urge that if we really don't have that much to fear if the court does do that. I think that the judicial standard is very likely to take into account those kinds of impacts on third parties and not allow them to take place.
So I just wanted to jump in, Richard, that the Fairness for All Act incorporates the Workplace Religious Freedom Act. So, that's just for you to remember when you evaluate the whole thing.
Yes, well, yes. And I'm always pleased to see where Religious Freedom Act show up anywhere. Please, Jenny, you wanted to say something.
And Richard, I would just say, folks might have been surprised. We did a friend of the court brief in the Abercrombie and Fitch case on behalf of a Muslim woman applicant for a position who was not considered because she was wearing a headscarf. And we definitely support the idea that there should be meaningful religious freedom protections in the workplace, and that it shouldn't be just really a nothing kind of a test. However, if I were working on drafting it, I would make it explicit that that freedom can't be a past for discrimination or harassment or different types of proselytizing and so forth. I mean, I think, I didn't have a big problem with the language included in the Utah bill that was making it clear that it was even-handed and so forth. But especially given a number of the judges that have taken the bench during this administration, personally, I would need to have very clear language in a statute before I would feel comfortable that civil rights would be protected.
And there were discussions to that effect back when I was working on warfare, and maybe Stanley, we could talk about that even for the fairness for all. Okay, so just stay with me. Let me see what else we've got here. So somebody wants to know, basically, what do we mean when we talk about carve-outs for religious institutions? Do we mean that they are exempt? So maybe, Stanley, maybe we could take a step back. Maybe we assume too much in terms of what people think we're talking about when we talk about exemptions for religious institutions. So speak to that if you would.
Yeah, so I guess, yeah, carve out, people just say, so then whatever that law is, that if it's a religious institution, this requirement doesn't apply to it. So it's kind of, carved out. And I think that's a little bit problematic concept, just as a general thing, as if some set of institutions aren't accountable, not responsible. So I don't like that way of thinking about things, although sometimes that's the only way to achieve accommodation. I think almost always, even if there's a carve out, it's not just you're exempt from everything. It may be a carve out with respect to some particular requirement. There may be some other requirement that applies. There may be some other kind of protection that's there or whatever. But yeah, just in general, carve out means that institution doesn't have that restriction placed on it. But I think we ought to always be looking for ways to achieve multiple goals. And I'm not sure that thinking about carve out is always the best way to go about it.
So we're running up against a hard stop in a moment, but I want, if anybody has any last words of wisdom, and then I have a concluding remarks to make. So this is the opportunity for anyone to speak very briefly, but to make any last points that you think we need to be made before we close.
So if I could just jump.
Yeah.
Sorry, Jenny. Just jump in quickly. So Jonathan said rightly that some Muslim people organizations are worried about the way the non-discrimination and religious freedom will work together. And I've heard the same thing a little bit differently from some conservative African-American religious people who are worried that now some forms of civil rights are being used against them in their religious activities and religious spaces. So we're dealing with very difficult things in which there's, different experiences across the board. And I think that's partly why civil rights law is very complex in the way it treats these different things, and they're not all uniform across all the titles.
The closing thought I would add is maybe to state something that I think has become increasingly obvious with time, but we LGBTQ people, we have always been here, and we are everywhere, and we're in your families and your workplaces and your houses of worship and so forth. And certainly the marriage equality movement caused a lot more people to get to know us as same-sex couples and know we have families. And now the same process, I think, is happening for our transgender and non-binary brothers and sisters and siblings. And I'm seeing the most acute pushback, and in some cases, but not always, demonization of transgender folks. And so I put out a call to people of goodwill and people of faith to open your eyes and your hearts and recognize that these are just people, and they're not scary and they're not dangerous. And, we need to treat everybody fairly and equally with the same legal standards that apply to everybody else. And if there are interesting questions to wrestle with, we should wrestle with them, but we shouldn't be doing it with any assumptions that anybody should be excluded and denied the benefits of support and inclusion throughout our public life.
Let me just say, there's a member of Congress who just in the last day said that there's no such thing as religious freedom. It's just a cover for discrimination. And so that, of course, we need to be careful in both directions, that not LGBTQ people shouldn't be demonized, and religious people shouldn't be demonized. We need to work together to resolve these issues. Melissa, Jonathan, last words.
Oh, well, I just also add, no one here is doing this, but sometimes in these discussions, and this was kind of a little flavor of this in some of the opinions of the court, an overlooking of the fact that there are, as Jenny, I think, said, many religious people who are themselves LGBTQ and who are allies of LGBTQ people. And so while there are dissenters from concepts like marriage equality in the religious community, there are also many religious allies and supporters of marriage equality in those communities. So that's just a part of the texture of the conversation that I think we all need to keep in mind. I think everybody here does that. It's just, it would be well if we continued to do that and didn't act like the religious community is monolithic, or that religious liberty issues are only asserted by conservatives. They're owned by religious people on the left and the right. And there's quite a diversity of opinion within religious communities about the issues that we're discussing today. So thanks, and thanks to everybody. I'm really glad to have this conversation.
And the only thing I'll say very quickly is, I agree with what everyone has said, that we need to approach these not as principles at tension, that are inherently at tension with each other. There are hard questions that need to be addressed, but that these principles can, and for many people, do coexist, and they can. And the last thing I will just say is that certainly, given all that has happened in our country over the last few weeks, when we think about discrimination, like, it has to also be clear that we're not talking about abstract concepts, but these are real pains and frustrations, legitimate frustrations that people have, and particularly for communities, of which, Stanley mentioned African-American communities, but certainly, African-Americans have no monopoly on knowing marginalization and oppression. And I think, we all need to, recognize and appreciate the harm that as a society we've done to many communities. And I think have those hard conversations internally about how we rectify that and how we make sure that we are making sure everyone has an equal seat at the table, because if we don't, I think we're seeing the ramifications of that.
Well, it's a wonderful message to finish with. Thank you to all those who are listening for joining us for this free webinar. We'd also like to express our gratitude for this esteemed group of panelists. You're all doing such critical work, and we thank you for taking the time out of your schedule to share your views. The section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And if you can, please consider joining and becoming active in the ABA. And in this section, you may do so at ambar.org/CRSJ. We also hope you consider making a charitable gift in support of our work in protecting and advancing human rights, civil liberties, and social justice at ambar.org/donate-CRSJ. And you can find information on other free programs on the CRSJ webpage, including the CRSJ co-sponsored webinar on this week's Supreme Court decision that is starting any moment now. So best of luck in your work, and stay safe, everybody. Thank you.